This is a Marshall Enterprises presentation. Peace, 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 and more peace, family. Welcome to the channel. This is Bud-Brownsville, and I got some more stuff to lay on you today. You're definitely going to enjoy it. Let's share the screen and get it going. Let's go. All right, so what we're going to be talking about is rebut, rebut, rebut. Any unrebutted affidavit stands as truth. Any unrebutted affidavit stands as truth. I said this before, I'll say it again. If I call you a bitch and you sit there quietly, twiddling your fingers, looking up into the sky, you don't respond, you're a bitch. But if I call you a bitch and you say, who are you talking to? I know that ain't me. I ain't no bitch. Do you respond? You're rebutting. That is what you have to do with these cases, with these processes. If you are served something, you must answer. I have individuals that say, who are they that we must answer them? I'll say it like this. You will be guilty by acquiescence. You do not want to fight your way out of the hole. You want to make sure you never see the freaking hole at all. You don't want to be on the defense. Did I say that right? You want to be more offensive than defensive, meaning before that ball is thrown into your court, you want to swipe it out the air. When that basketball is thrown up against that or attempted to be thrown into the basket, you have until it starts to come back down. Those that know basketball, you have until it starts to come back down before you can swat it. If that ball is tossed up and you swat it out the air, fine. If you hit that ball as it's coming down towards the basket, then that is a goaltending. You know, so there is a time and a place for everything, and everything has to be addressed accordingly. All right, so I don't want to start with this one. Let me start with this one here. And this is a pretty well-known case. I am not going to go into the details of the case. That's not really much what I do. I present the stuff for you, and you need to do your due diligence. There's a reason why I am showing this to you, which means I've done my due diligence, and I use this as a reference. If I didn't do my due diligence, I wouldn't be able to use it as a reference. But I've done the prerequisite homework on my end, so that's why I'm bringing it to you, and you can do the research on your end. We got to do this together. I can't do everything for you, all right? With that being said, bench. I have considered the defense motion, and that will be the judge. I have considered the defense motions, and they are all denied. Real man, I did not file any motions. I filed affidavits. Bench, meaning the judge. Well, I am treating your documents as motions. Real man. Again, I did not file any motions. I filed affidavits. It is a criminal offense to file a false affidavit. I notice I am not under arrest for filing a false affidavit, so it is clear that my affidavits are true, correct, and accurate. An affidavit is a statement of truth, so my uncontested affidavits are the truth. I'm sure this court isn't deliberately denying the truth in order to falsify the record. I'm certain it isn't this court's intent to falsify the record and create denial of due process, is it? It's the case of Morris v. National Cash Register versus Group v. Finletter. Defendant is likely to be the only individual now or in the future who is willing and able to place a sworn affidavit affirming the herein disclose facts under penalties of perjury into the record of this case, and as such, in the absence of a sworn counter affidavit signed under the penalties of perjury regarding the same facts, laws, case laws, and evidence, defendant should not, or defendant should be the only prevailing party. Mars v. National Cash Register, 44 SW 2D 433 clearly states at point number 4 that the uncontested allegations and affidavit must be accepted as truth. And the federal case of Group V Finletter 108 F Sup 327 states allegations and affidavit in support of motion must be considered as true in absence of counter affidavit. Now, for those listening that heard me read those case notes, the citations, never mind, I'm gonna do it. I'm not even gonna do it. Not even gonna do it. Anyway, let's go over here. Are you familiar with this document? You need to be very familiar with this document. Canon 3228, the 12 presumptions of court. Please, please Google this, look it up, and read it for yourself. What I will read out of this one will be summonses, and I think I'm going to read the guilt part. Let's go to summonses. The presumption of summons is that by custom, a summons, unrebutted, stands, and therefore one who attends court is presumed to accept the position as defendant, juror, witness, and jurisdiction of the court. Attendance to court is usually invitation by summons, unless the summons is rejected and returned, with a copy of the rejection filed prior to choosing to visit or attend. Jurisdiction and positions as the accused and the existence of guilt stands. And briefly, in their courtrooms, it is a stage play. It is a well-coordinated, well-organized stage play. And they have actors in there. They have roles. And there are several roles that are available depending on how you carry yourself, how you present yourself, how you defend yourself. Now, the title of judge most likely is going to be taken. The title of prosecutor most likely probably will be taken. That leaves witness and it leaves defendant. You do not want to come in as a defendant. Choose another role. You can come in as a witness. You can come in as an uninterested third party. There's several positions that you can use other than the ones that they give you. Just as they give you two options. How do you plead? Guilty or not guilty? I wish I can pull up that document, which I'll do a video on that one as well, of all the additional pleadings available to you other than guilty or innocent, or not guilty or guilty. They're not going to tell you. You are supposed to know. We are presumed and assumed to know a certain percentage of law. It's an unspoken requirement, so to speak. Like, you should know, hopefully you know, but they pray you don't know. But you should know these things. You should have these basics down pat. And going forward in the next couple of months, I'm going to go hard at trying to reach our 18 to like 25-year-old individuals. And if I can get them younger, the younger the better. We need to know our defenses. We need to know what our rights. And we're waiting much too late. And it's never really too late, but we're waiting too late, too long to get this information when it should be given to us in public school. It should be given us at home prior to us going to school. We should know this like we know our ABCs. But anyway, look out for those videos and those presentations coming up. I want to try to reach our young folks. It's very important. So this is the summons, and this has to do with the tickets that you receive, which I'll do another video on that one as well, how to handle the tickets. I personally am never paying another ticket in my life. Mark my word, I will never pay another ticket in my life or summons. I know what to do with them. You need to know what to do with them as well. Guilt. The presumption of guilt is the presumption that as it is presumed to be a private business meeting of the Bar Guild, you are guilty, whether you plead guilty, do not plead, or plead not guilty. Therefore, unless you either have previously prepared an affidavit of truth and motion to dismiss with extreme prejudice onto the public record, or call a demurrer, then the presumption is you are guilty, and the private bar guild can hold you until a bond is prepared to guarantee the amount of the guild wants to profit from you. Right, let's do one more. Let's do one more. And I have a visitor. Excuse me for 1 second. Sorry for that inconvenient. I want to read the custody. The presumption of custody is that by custom, a summons or warrant for arrest, unrebutted, stands, and therefore one who attends court is presumed to be a thing, not a person, and therefore liable to be detained in custody by custodians. This includes the dead legal fiction, non-human person that corporate governments rules and regulations are written for. Custodians may only lawfully hold custody of property and things, not flesh and blood soul possessing beings. Unless this presumption is openly challenged by rejection of summons and or at court, the presumption stands you are a thing and property, and therefore lawfully able to be kept in custody by custodians. Rebut, rebut, rebut. Rebut, rebut, rebut. If you are arrested, let's say you brought up a charges, you come in contact with the police, you got a police report. Always get a copy of that police report and rebut it. Rebut it and return it. Return it meaning you want to put it on file. Like if your case is going before civil court or criminal court 3, wherever that case is going to be held or the play is going to be performed, you want to put your rebut. I'm saying I'm speaking too fast. You want to rebut that police report, which is an affidavit. They're making a statement about you. You want to rebut it, make a copy of it, and put it, make a true copy and put it on file in that court. You need to rebut, otherwise it stands as true. It stands as truth. I hope you're getting these people. Let's go to Rule 301. It's the presumption in the civil cases generally. In a civil case, unless a federal statute or these rules provide otherwise, the party against whom a presumption is directed has the burden of producing evidence to rebut the presumptions. But this rule does not shift the burden of persuasion, which remains on the party who had it originally. All right, I think I said enough. Maybe not, but I have a good group of individuals that follow and watch my videos, so I look forward to the feedback. Let me know if I need to further clarify what needs to be done, how it needs to be done. Hit me. Let me know what I need to do. Is it clear enough or it needs to be clearer? All right. I'm looking for interaction, people. I thank you for taking your time out to listen, watch these videos, these presentations. I hope it provides some answers. It connects some dots for individuals that are missing a piece. And I hope this makes you think. I hope this gets you thinking. We need to get this information out to the younger crew, our younger brothers and sisters. You know, we need to start exercising our rights. And you have no rights if you don't know what your rights are. You have no rights if you're not using them. Use it or lose it type thing. All right. And no one can exercise your rights for you. You have to assert them yourself. No one pushed you out of your mother's stomach. You pushed yourself out. Other than, you know, her bodily functions, you know, what's the word I'm looking for? You know, the contractions squeezed you out, but no one was there to help you. So in these cases, unless you get a mouthpiece, aka a lawyer or an attorney, which I can show you also why you shouldn't, but that's on you. You need to be able to stand on your own square and not represent yourself. You want to stand as yourself in court. All right, give me more a little later. Thank you. This is Bud-Brownsville. Appreciate your time. I appreciate you listening. Appreciate you sharing and clicking like. And you need to share, like, and subscribe. Right. Thanks again. Peace, peace, and peace.